we've been waiting for years for a fiduciary standard to come out of the SEC, and we're still waiting. The closest they've come is to tell us that at the end of 2016, they're going to issue a notice of proposed rulemaking. It's a little bit like your cousin telling you, well, look in your mailbox in about a year, we're going to give you a save the date for a wedding. So we're not holding our breath too hard on an SEC rulemaking around fiduciary standard, but the Department of Labor is moving ahead very firmly on its own fiduciary standard. We wish the SEC would have moved, because then it would have applied to all investment accounts, not just retirement accounts, but you get what you get. The Department of Labor is moving ahead. That's the number one issue, I believe, in the regulatory arena facing advisors in 2016. We're going to see a rule finalized late March, early April, something like that. It's going to be effective maybe 1/1/2017, something like that. It's going to impact advisors. I believe this has been an underreported fact that the Department of Labor fiduciary standard rule is going to impact advisors in two ways. One is selling of IRA rollovers, i.e. advising clients when they're leaving a company to roll their balance out of their 401k plan into an IRA managed by the advisor. And secondly, if they're advising on derivative securities. The proposed rule listed certain securities that were okay to advise on in a retirement account, the standard stuff, mutual funds, ETFs, stocks, corporate bonds, treasury bonds, etc. And in certain things that are not going to be okay to advise on in retirement accounts, non-traded REITs, derivative securities. We have a lot of advisors who are now recommending derivative securities to protect concentrated positions and for other reasons in portfolios. That's not going to be allowed anymore, at least under the proposed rule that the Department of Labor is working on finalizing now. If they're advising on IRA rollovers, they may very well have to fall under this best interest contract that the Department of Labor is laying out. What does that mean from a pocketbook perspective? They're going to have to hire an attorney, a securities attorney, or an ERISA attorney to craft this document for them and to present it to clients and make sure it's executed. There are a lot of compliance steps under that exemption in this law if you have to fit under it. A lot of reporting and disclosure obligations on an ongoing basis. There's also private right of action, which means you are guaranteeing in that contract that you are giving advice that's in that client's best interest, including the advice to roll over their balance from their 401k. And if later the client feels like maybe that wasn't in their best interest, there's a litigation risk there as well for advisors. So there's some definite upfront cost, and there's some risk of higher cost down the road as well.